Now streaming live. Okay.
Just one moment, please, while it connects. Okay, please go ahead.
Streaming live. Okay.
Just. All right, ready to go.
Great, thank you. So good morning. This is public hearing in Children and Family Law. As Chair of the Children and Family Law Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic and in accordance with House Rule 67 and the governor's emergency order number 12 pursuant to Executive Order 2020-4, this public body is authorized to meet electronically. This is a public hearing on bills referred to the committee. An executive session may follow. Please note that there is no physical location for members of the public to observe and listen contemporaneously to this meeting. However, in accordance with the emergency order, I am confirming that all members of the committee and select legislative staff have the ability to communicate contemporaneously during this meeting through the Zoom electronic meeting platform. And the public has access to contemporaneously listen and, if necessary, participate in this meeting by the Zoom platform or by telephone. All necessary access information has been made available in the House calendar and through the electronic calendar on the General Court's website. The notice for this meeting notice complies with House rules and RSA 91A. Anyone who has a problem accessing the meeting should call 271-3600 or email hcs@leg.state.nh.us. In the event the public is unable to access the meeting will be adjourned and rescheduled. Christina Dyer is the staff assisting us. Please note that all votes that are taken during this meeting shall be done by roll call vote. Let's start the meeting by taking a roll call attendance. When each member states their presence, please also state whether there is anyone in the room with you during this meeting, which is required under the Right to Know law. Representative Alicia, please call the roll.
Thank you, Madam Chair. Representative DeSimone.
Here, I am in the committee room with other legislators.
Thank you. Representative Okila. Representative Okila.
Who?
Yokella.
Yokella.
Representative Yokella.
No.
It appears he's not there. Thank you. Representative Lewicki.
I'm here in the committee room with the other reps.
Thank you. Representative Bellinger.
Belanger, and I'm in the
Bellinger.
I'm in the committee room with the other legislators.
Representative Cross. Representative Cross.
Who?
Representative Cross. Keno Cross.
She's saying cross.
Can you hear me?
Now.
You're a little faint, but Representative Cross is not here in the room. I know that, and I don't see her on
And
the
I
screen.
don't see her on the list.
Representative Litchfield.
Is
Here, I am present and in the legislative room with the other representatives.
Representative Smith. Representative Long.
Here, at home, alone.
Representative Alicea, I'm here and I'm alone. Representative Grossman.
Good morning, everyone. I am here at home with 3 remote learners and my husband as well.
Thank you. Representative Levesque?
I am here in my kitchen. My dog might come in and out.
Thank you. Representative Wazir?
Good morning. I am here in my home in Concord with my husband and 3 of my kids, remote learners.
Representative Petrino?
Hi, I'm here alone in my home office.
Representative Altschuler?
Good morning. I'm here in Stratham in my home office.
Alone?
Yes.
Thank you. Representative Rice?
I am here in the LOB in the committee room with several colleagues. And Madam Chair, I've noticed that Representative Yokella has appeared on the screen.
Okay, thank you.
Representative Alisea, you are muted. We cannot hear you.
Representative Alicia, you're muted.
You can also hit the space bar, Representative Alicia, if you want to speak briefly.
I've completed the roll call list.
Did you call Representative Yokella? Because he's appeared now.
Okay.
Sorry, I was late. I had a presentation of my bill. I'm here in my home alone.
Thank you.
Thank you, Representative Alicia.
Thank you.
Okay, so good morning, everyone. I am going to open the public hearing on HB 188.
Excuse me, Madam Chair. Yeah, can I read the mask?
Okay, yes, once Representative DeSimone is going to read the mask policy briefly.
This mask policy is for when you are at the LOB. You shall wear your mask when you're not in your seat or when you're not within at least 6 feet of another person, or if you are in a common area, which means the hallway, restroom, stairway, you shall wear your mask. Thank you.
Thank you, Representative DeSimone. So our first speaker on House Bill 188 is Representative Paul Birch to speak in support of his bill.
Okay, let me just find Mr. Birch. I can't find him yet. There he is. Allowed to talk. Good morning, Mr. Birch.
Good morning.
Press.
As we say, can folks hear me?
Yes, thank you, Representative Birch. Go ahead.
Okay, thank you. And good morning, everyone. My name is Paul Birch. I'm a representative from Cheshire 1, which encompasses the Connecticut River towns of Walpole, Westmoreland, Chesterfield, and Hinsdale.
Excuse me, Representative. Can you just speak a little louder? It's hard for us to hear you.
Okay, be glad to do it. It's a rare request to me. I will do my best. I am in my 5th term and a member of House Judiciary. And if people didn't catch it, I represent folks in Cheshire 1 along the Connecticut River, which is Westmoreland, Walpole, Chesterfield, and Hinsdale. Relevant to this, I am also the judiciary designee on Judicial Council, and which has had and you will hear a significant role in the development of HB 188. I appreciate the opportunity to speak here, and I'm, as always, so pleased that the chair appears to be in such good health, and that's it's good news for all of us. So, without further ado, HB 188 is titled Relative to Appointment of Counsel in Juvenile Court Proceedings. And the focus of this bill is to improve the delivery of that particular service in the juvenile justice system. That is the appointment of assigned counsel when necessary. The reason this bill was drafted was that the Judicial Council some time ago commissioned a report that was to analyze the affording of counsel to juveniles in the juvenile justice system and how effective that has been. That job was done by the National Juvenile Defender Center, and I have sent, and hopefully you have all received, a copy of that report. In some respects, if you read the report, you probably don't have to listen to me. But given how busy we are, shall we say, you get me to give the head note version. Okay. As a result of receiving this report, which had maybe 50 or so recommendations for improving the delivery of legal services to juveniles in the juvenile justice system, at the suggestion of the Judiciary Chair, then Marjorie Smith, I formed a working group to see what we could do to take these proposals and see what would stand a chance of passing and being enacted in New Hampshire. It was a distinguished group of Republicans and Democrats, lawyers and non-lawyers. It included then Judiciary Chair Marjorie Smith, and now and the current Judiciary Chair, Representative Gordon, who's also a retired judge. Representative Waltz was on that, who's been a prior chair of Children and Family Law. Representative Long was kept apprised from time to time about this, and Representative Levesque contributed to that group also. The group met numerous times, both with the I was interfacing with Judicial Council. We met with practitioners, we met with court people, we met with providers, we met with a representative of the juvenile defender system, and we put this bill together. I want to briefly say that there are a whole host of areas that we decided not to touch just because it was too big an ask. We are not dealing with the issue of detention hearings, diversion. We're not talking about use of law students in the diversion process. We're not talking about police, use of police as prosecutors. We're not talking about school resource officers, which is a big issue. We decided not to get into the issue of certification of children to adult court, and we didn't get into the establishment of performance and other standards. So if you think this bill accomplishes a lot, there's a whole lot more that we decided not to focus on. So the major areas that this bill deals with, the first and perhaps the most important, is to require appointment of counsel when the petition is filed. And that's when the court gets the paperwork. It's expected at that point, the court will assign counsel to the juvenile. And that means prior to the first hearing in court, there's required to have an opportunity for the juvenile and counsel to consult. The notice to assign counsel is to be provided the same day as the petition is filed, and that can be done electronically, telephone, carrier pigeon, St. Bernard, whatever it may be. But the idea is to get that done as fast as possible so that some communication between attorney and the juvenile can occur before getting to court. And while a juvenile and a parent or guardian can waive counsel, we do have a mandatory provision that can't be done until and unless the juvenile and the parent or guardian has had an opportunity to discuss the wisdom of waiver with counsel. Now, our current statute has some of these provisions in it. They're not necessarily widely used. For instance, there is a provision where a juvenile with his or her parents can consult with an attorney about getting counsel at no fee. The cost of that would be billed to the judicial council. Our information is that it is rarely, if ever, used. And that seems to be a problem in a lot of areas in our current juvenile law. There may be provisions that are not often used. So by getting counsel appointed early, right off the bat, then a lot of other things fall into place. There's one tweak that may get mentioned later, and that may require a small amendment or not, depending how the judicial branch looks at it. And that is, if the court doesn't have sufficient information at the filing of the petition time to decide whether the juvenile is indigent or not, the appointment should be considered provisional and subject to the court reviewing that at a later date. And it's the same thing as if somebody is appointed counsel and the person, wins the lottery. The court can always go back and say, well, you no longer need the services of a paid-for lawyer. So if that needs to be clarified, and it's not sure that it does, that's a small tweak that can be made. The second big area of the bill is to require counsel to be available for consultation if there's to be police interrogation of a child. The preliminary material to the bill before the actual working part, the preamble, makes mention of the Supreme Court's point of view, it's U.S. Supreme Court's point of view, is that children do not feel that they can just terminate an interview with the police or walk out when the police are talking to them. Children are different than adults. So that becomes basically a custodial situation. It isn't a whole lot different than Miranda. It's basically Miranda. And what this bill says is that if it doesn't bar the police from talking to the child, it simply says that anything said by the child, if that child has not had an opportunity to consult with a lawyer, cannot be used against that child in a further in a prosecution of the child. The implementation of that is being left to be worked out administratively. How that counsel would be practically done may be different in Manchester and Nashua, where an attorney might be nearby and can physically go over. It might be quite different in the more rural parts of the state, in the northern part of the state, and that consultation with an attorney can be done telephonically if privacy is ensured and other protections are there. So the principle of it is set out in the statute, and I think the judicial branch and the judicial council and interested stakeholders can work out how that would be done administratively. The third major area is that the fee for counsel for appointed counsel in juvenile cases would be ended. Now, a characteristic of our juvenile justice system is that the parents pay at virtually every stage of the process. And what it means is a lot of those stages aren't accomplished because the parents cannot, will not, choose not to pay. For instance, there is on the books a right to appeal. If you have a bad decision in your opinion in juvenile court, you have a right to appeal that. But a parent would have to pay $2,000. So out of the thousands and thousands and thousands of cases that occur annually, I think there have been 4 appeals in 5 years. So you can have an appeal right on the books, but it doesn't really exist. We didn't want to go through, despite the recommendations from the report, and eliminate all of the parental payments throughout the entire line of the juvenile case. We thought that was too big an ask. So what we're doing here is saying the right to counsel for that kid is not going to be dependent on whether the parents can or want to pay for their kid's lawyer. The kid is entitled to that. It's a kid that's going to go through all the processing, and a kid is going to go through everything else. And that's an important right of that child. And I want to emphasize at this point that what we're talking about here are constitutionally required rights. We're not talking about what would be nice to have and what's not nice to have and what would be cool and not cool. The right to counsel for juveniles in juvenile justice is constitutionally required under the United States Constitution. And that means, to put it frankly, the best way to see that that's effectuated is through the legislature as opposed to going through the courts. We are the people's representatives. It's also cheaper, more effective, and more nuanced, I think, if we as legislators do that. The second thing I wanted to point, as long as I'm taking a little side trip, is we hear a lot of anecdotal evidence in New Hampshire, and this is true in a lot of states. We get bills that come up and people come in and tell anecdotes. And I listen to a lot of the Bail Reform Commission hearings, and you would get people coming in and saying, well, my experience is this, my experience is that. And gee, from what I see, everybody's back out on the streets 10 days later, and somebody else comes in and everybody is locked up and nobody's out on the streets. The data here and the information here is backed up by data, not anecdotes. And later on today, a representative, or this morning, a representative of the National Juvenile Defender Center who put the report together will in fact talk about specifics of our juvenile justice program. So you know that we're talking about something that's fact-based rather than anecdotal-based. One last area, and which will also be discussed, is we will be eliminating by this bill flat fee contracts for representation of juveniles by private counsel. What we have is a system now, which is not all that common in how these are set up with other agencies, is a lawyer is paid a flat fee to handle a certain class of cases. And it's not dependent on how complicated the case is or the amount of work required for that case. And unfortunately, what that means is if a lawyer's getting paid $300 to handle a case, the client's going to get $300 worth of work, whether the case requires $300 worth of work or $1,500 worth of work. I mean, that's just the reality of real life. So the recommendation from the National Juvenile Defender Center, and consistent with what happens in most contracts in the state of this nature, payment of assigned counsel will be based on an hourly rate, and that would be decided by the judicial branch. So, and that would presumably be in conformity with how it's done with other similar circumstances. So those are the major areas of what this bill does. And it basically will ensure that counsel is there sooner, that counsel has effective time to talk to clients, that, oh, there's one other area to mention. The bill also makes it clear that representation shall be on all matters related to the subject matter of the petition. So that if there are appeals, if there are collateral placement issues, that attorney who's already familiar with the case continues to work on the case. But we put a limitation in saying it has to be within the subject matter of the petition. For instance, the juvenile may also have, let's say, an IEP issue. Nothing to do with the petition or why the child is in juvenile justice system. This does not mean that an attorney is mandated to be appointed for that child for the purposes of IEP proceedings. Representation shall be full and wholesome for everything that has to do with the subject matter of the petition and of the petition only. And the last thing I want to do before I turn it over to some others and answer any questions is to note that the major recommendation from the National Juvenile Defender Center was to completely switch over the system to one of specialized attorneys handling juvenile matters exclusively. And in many respects, that is the best practice. Because if you have highly trained specialists, many of these changes will flow from that. However, that seemed to be in an age of budget crisis and other issues, an unrealistic ask to reform the system in that matter. So what we've decided to do in our working group was to say, okay, we're not going to toss out the whole old system and put in a new best practices system. We are going to try to make at least the necessary changes to keep the car on the road. And that's what we're trying to do here. I do want to say and give credit to the Judicial Council that although we are not in this bill talking about establishing state qualifications and performance standards, that there is a serious effort by the Judicial Council to continue with, improve, and make ongoing the training of lawyers who handle juvenile cases. That is ongoing, it has been ongoing, and it will be ongoing. And I think mention needs to be made of that. So that's my overview. I know I spoke for a while, and if there are questions, I'm happy to answer. If not, there's some more people who can give specific answers.
Thank you, Representative Birch. Are there any questions from the committee members? Representative Yokella?
Hi, thank you for recognizing me, and thank you for taking the question. Is this, you mentioned the constitutionality of required right to counsel, and is it your understanding that that requirement is for criminal cases or strictly, or also for civil cases? And what does this fall under? And is there a requirement, seeming requirement in this bill to allow or require the opportunity for representation in civil cases? Thank you.
Thank you for your question, Representative, and it's a good one. In juvenile land, it's referred to as delinquency cases, as juveniles presumably cannot commit crimes, they do delinquent acts. But but the same concept. This bill relates only to the delinquency aspects. And I think the constitutional mandate on those is absolutely clear. How I personally believe that the liberty interests are such in children in need cases that an argument can be made that there are constitutional requirements, but I'm not making that argument today for civil matters. This is not civil today. But I'd be glad to visit with you personally on that and talk about it further.
Okay, are there any further questions? Representative Lewicki.
Thank you, Madam Chair. I don't see a fiscal note attached to this. Do we have a good idea of, any idea of how much it's going to cost and how we're going to appropriate that money?
All right. No, there's no fiscal note. And the representative from the Judicial Council will speak a bit as to the costs of this bill. In many of the changes will have very little financial impact. Having a council appointed sooner rather than later has very little impact. One area that may have an impact is in the assigning of counsel or the provision of counsel to a juvenile who's being questioned. If it's done by telephone or similar means, the cost would be fairly minimal. If it's done by having a public defender head over to the police station, and that's going to entail greater cost. The overall costs I don't think are going to be huge, but someone else will be speaking more directly to that.
Thank you, Representative.
Okay, and just a reminder though that we vote on the policy, not the price tag that goes along with it. We vote whether or not we support the policy going forward, not the financial aspect of it. Are there any more questions for Representative Birch? Okay, seeing none. Thank you very much, Representative Birch. And up next is Christina Gilbert, a member of the public who is representing the National Juvenile Defender Center to speak in support of the bill.
Thank you. Can you hear me?
Yes.
Great. Thank you so much. Chairwoman Rice and members of the committee, thank you for giving the National Juvenile Defender Center, NJDC, the opportunity to provide this testimony on HB 188 and how it comports with national best practices regarding appointment of counsel in juvenile court. My name is Christina Gilbert. I'm a senior staff attorney and policy counsel at NJDC. NJDC is a nonprofit, nonpartisan organization dedicated to promoting justice for all children by ensuring excellence in juvenile defense. We believe that all youth have the right to ardent, well-resourced representation, and we work to improve access to and quality of counsel for all young people in delinquency court. We provide technical assistance, training, and support to juvenile defense attorneys across the country, and support the reform of court systems and policies that negatively impact our nation's youth. We've also supported effective and developmentally appropriate juvenile court reform through assessments of access to and quality of juvenile defense counsel at the state level. To date, we've done 28 assessments, including the release of our New Hampshire assessment last August, which I believe you all have. Our work in both New Hampshire and nationally provides us with a unique perspective on appointment of counsel in juvenile court and the efforts to protect the due process rights of youth across the country. We support efforts to ensure children are afforded legal counsel at the earliest possible interaction with the legal system and throughout the time of court involvement. HB 188 is an important first step, requiring the appointment of counsel once a delinquency petition has been filed or summons issued and before the child appears in court. Moreover, requiring that young people can consult with counsel prior to waiving the right to counsel is vital to due process protections. The provision prohibiting admittance of a statement from an unrepresented minor in any judicial proceeding is also critical to ensuring young people's rights. We also support the other provisions of HB 188 that were mentioned here, but because this bill covers such a range and there will be others speaking, I'll limit my remarks to the appointment of counsel. More than 50 years ago, the United States Supreme Court issued in re Gault a landmark decision declaring that children require the guiding hand of counsel at every step in the proceedings. This vital constitutional right to counsel must begin prior to the child's first appearance in court. Since Gault, state legislatures and courts have grappled with how to implement that right for a population that is developmentally different than adults and needs safeguards to protect their rights. Too often in courts across our country and in New Hampshire, a defender will not meet their client until the first appearance at the courthouse. If they are lucky, the defender and child might have 5 to 10 minutes to discuss the case in the upcoming hearing. If they're not so lucky, the defender might get only a few whispered comments to their new client while standing at counsel table just before the hearing begins. This falls far short of what the Constitution requires of the right to counsel. If counsel is not appointed until the first court appearance, the child and their family must walk into the courthouse with little to no understanding of what is happening, leaving them overwhelmed and confused. One of our key findings in our New Hampshire assessment was that the appointment system does not provide counsel to youth early enough. As a result, they may appear at their initial court hearing without counsel and enter pleas without ever consulting with an attorney. In our assessment, we make the recommendation to automatically appoint counsel for all youth before their first court appearance and ensure they're represented throughout their involvement in the legal system. HB 188's requirement that the appointment of counsel shall be made sufficiently before any hearing to allow for consultation between counsel and client, as well as for any appropriate investigation, is an important step toward ensuring that young people have the opportunity to fully participate in their own defense, which is what the Constitution requires. In recognition of the developmental differences of young people, New Hampshire has already put some safeguards in place, severely limiting how and when a young person may waive their right to counsel. However, NJDC observed through our assessment that in some jurisdictions, many children were still waiving their right to counsel and pleading at arraignment without ever consulting with counsel about their right to an attorney. HB 188 would add the additional safeguards necessary to ensure that all children in New Hampshire, regardless of jurisdiction, receive the benefit of this protection. Involvement in the delinquency system can create a multitude of barriers to a young person's future opportunities for employment, housing, and education. Juvenile defense attorneys can play a significant role in helping eliminate such barriers. Comprehensive representation by juvenile defense attorneys encompasses a wide range of in and out of court advocacy. Currently, under New Hampshire law, representation for youth in delinquency proceedings automatically ends 30 days after disposition, unless a post-dispositional motion is filed within that time frame. The provision of HB 188 that requires representation include related proceedings related to the same factual circumstances, allows for more holistic advocacy by attorneys, which allows for continued communication and rapport building, which is especially critical with young clients. Finally, we also support the position that not only that children have sufficient opportunity to consult with counsel before any statement or confession is obtained by law enforcement, that may not be used in court. Developmental research suggests youth may be more susceptible than adults to interrogation pressures because they are less likely to understand the legal process or their rights, have less impulse control, and are more prone to risky decision-making, are more susceptible to immediate rewards, and have more difficulty in anticipating the consequences of their actions. They're more likely to comply with authority and are more susceptible to peer influence. Based on the existing research, it's clear that special caution is required when interrogating youth. Requiring access to and consultation with counsel prior to the use of any confession or statement obtained by law enforcement upholds children's constitutional right to counsel and ensures the integrity of investigations involving children. As long ago as 1948, the Supreme Court asserted, "We cannot believe that a lad of tender years is a match for the police in such a contest. He needs counsel and support if he is not to become the victim first of fear, then of panic." More recently, the Supreme Court held that age informs the Miranda analysis for custodial interrogations because children subjected to police questioning often feel more pressured to comply with authority than adults. The Supreme Court aptly stated, "By its very nature, custodial police interrogation entails inherently compelling pressures. Even for an adult, the physical and psychological isolation of custodial interrogation can undermine the individual's will to resist and compel him to speak where he would not otherwise do so freely." This bill would assist children in understanding their rights in the legal process before they are subject to the overpowering presence of the law. Studies have found that in the absence of counsel, almost 90% of children waive their Miranda rights, with few children understanding the rights they're waiving. This leaves children literally defenseless in the face of trained professionals seeking to secure confessions. HB 188 will afford children earlier access to counsel throughout New Hampshire and provide the child and attorney proper time for consultation before any court hearing. NJDC strongly supports HB 188 and respectfully urges the legislature's support. Thank you. And I'm happy, we'll be submitting written testimony with additional details and support, and I'm happy to answer any questions now as well.
Great, thank you so much. Are there any questions from the members of the committee? Representative Yokella.
Hi, thank you. And thank you for taking the question. In the assessment that you created, did you find any conclusions that are contrary to the stated mission of the group that you represent?
I'm not sure I entirely understand your question.
So you made a bunch of statements about what the goal of your group is,
yeah,
and the stated mission, and then you made an assessment on New Hampshire, and I'm wondering if you found anything unusual or contrary to your stated mission in the assessment of New Hampshire.
Sure, and I can say, you know, our assessment, we can't go to every court and every jurisdiction, so there are certainly limitations. However, we found a lot of strengths. There are a lot of strengths in New Hampshire to the juvenile defense system. What we primarily found were a lot of systemic barriers to, I think in New Hampshire, most people working in the juvenile justice system and the juvenile defense system had the goal of excellence in juvenile defense and promoting justice for children and ensuring the constitutional right to counsel. I should say in our interviews across stakeholder groups, judges, defenders, probation officers, the majority of people we talked to saw no reason that counsel couldn't be appointed earlier and thought that children needed it. So I think a lot of what we found were more systemic barriers getting in the way of, you know, reaching that mission.
Thank you.
Any further questions from members of the committee? Thank you very much, Ms. Gilbert.
Thank you.
Next up is Michael Skibby, a lobbyist with the Disability Rights Center, to speak in support of the bill.
Thank you, Madam Chair. Can you hear me?
Yes, thank you.
Good morning. My name is Michael Skibby. I'm the Policy Director at the Disability Rights Center. I appear on behalf of the Disability Rights Center and on behalf of the Juvenile Reform Project, which as many of you are familiar with. It's a coalition of groups that have been involved in reform of the juvenile justice system over several years. It includes New Hampshire Legal Assistance, my office, the ACLU of New Hampshire, Waypoint, and New Futures. My experience earlier in my career involved a fair amount of involvement in the juvenile justice system. I spent the first 17 years of my career at the Public Defender Program as a lawyer, as a supervisor, and ultimately as director of the program. I've also been a consultant on indigent defense issues in California and Pennsylvania. I'd like to begin my testimony just by talking about how pervasive disability is in the juvenile justice system, and that's really why my office has been involved in these reform efforts for so long. Most research focuses on the population of children that end up in facilities where more information is available than just children who show up in court. And that research is really striking. It shows that about 70% of kids or more in juvenile facilities have disabilities, typically behavioral disorders, but a wide range of disabilities. It may even be higher in New Hampshire. I was present at a legislative hearing 2 years ago where representatives of the Department of Health and Human Services said that fully 100% of the children at the Sununu Center in Manchester had a disability of one sort or another. Now, the high representation of kids with disabilities in the juvenile justice system is due to a variety of reasons and dynamics. One is, as you might imagine, when someone has a disability, they often experience school failure and alienation from peers that might be, positive influences if they weren't alienated from them, alienation from coaches, teachers, other non-parent adults. They may have difficulty with impulse control. They may have difficulty understanding and conforming to rules and structures that they're subjected to. Maybe difficult for them to consider the consequences of their behaviors. And also they may have more difficulty than their peers at misbehaving successfully, if you will. They tend to be pretty unsuccessful actors when it comes to violating the law, and it's very difficult for them to get away with it as compared to kids without disabilities. The other thing that I think is very important to think about is that there's pretty good evidence that kids with disabilities are processed in the system differently. They tend to have more difficulty dealing with encounters with authority figures, including teachers dealing with discipline issues, police, prosecutors, and judges after they may become involved in the system. And that's part of the reason that you see kids with disabilities getting deeper and deeper into the system as compared to their non-disabled peers. So this high rate of disability is extremely important to consider when you're thinking about the importance of having trained and skilled lawyers involved in the system to assist these children as early as possible and throughout their involvement in the system. Turning to a couple of specific portions of the bill, first I wanted to address the section that eliminates the use of flat fee contracts, which is section 7 on page 3, line 10. Now, the indigent defense system for both adults and children in New Hampshire basically has 3 principal components. The vast majority of cases are handled by the Public Defender Program, which is a large nonprofit law firm that has a contractual relationship with the state. It has lawyers on staff. They don't charge the state on a per case basis. They basically have a large contract that provides for a certain number of lawyers throughout the state to handle a variety of cases. The second tier of the system handles most of the remainder of the cases, and that's a contractual system where private lawyers enter into contracts with the state through the Judicial Council to provide cases in various categories, and they do that for a flat fee. That is, for a misdemeanor, you get a certain number of hundreds of dollars. For a felony, a couple of $1,000s. I don't really know what the number is anymore. And for juveniles, it's a flat fee as well. There's a very small number of cases that are also handled on an hourly rate, but the system really has very few of those left. Most of the cases are handled by these previous 2 components I mentioned. Now, the problem, as you can imagine, is that a flat fee means that every action that you take reduces your hourly rate that you're actually being paid. Because regardless of whether you spent 20 hours on a case or 3 hours on a case, you're getting the same amount of money. So the incentives are all in the wrong direction. Now, the hourly rates that the system pays for lawyers handling cases on an hourly basis, either in the criminal system or other parts of our system, are way below what lawyers typically make. And long ago, they were surpassed by the average overhead rate of a New Hampshire law firm. But at least when you get those low hourly rates, you get paid more for more work. That doesn't happen with the flat fee system. Now, in addition to this, setting the flat fee is inherently a blunt instrument because the demands of the case are highly variable and unpredictable.
Mr. Skibby, you're fading a little bit. Can you just speak up a little bit for us?
All right, sorry about that. It's highly dependent on what kinds of legal issues are in the case, the facts of the case, whether the minor has a disability and how complex that disability is. That may involve evaluations, consulting with experts, doing research outside the law. The actions of the prosecution and of the judge can trigger extra effort on the part of the defense. So it's extremely difficult to predict at the outset what these kinds of cases are going to take in terms of effort. So any system that uses a flat rate is likely to undercompensate lawyers in a vast not a majority of cases, but a significant fraction of those cases. So those are my comments about the flat rate system. I urge you to adopt that portion of the bill so that lawyers are paid more for more work. Next, I want to talk about the early appointment section, which is section 2, which it's sections 2 through 4, all of which are on page 2. Now, when a delinquency case is begun in New Hampshire, there's really no lawyer until the first time that the family and the child show up in court. The only exceptions for that are if a lawyer is hired by the family, that's a very small fraction of the cases, or if the police are asking the judge to lock the kid up at the Sununu Center at the very beginning of the case. The law in those cases requires that a lawyer be called over to represent the kid at that particular hearing. But typically, a child will go to court without a lawyer and with little or no understanding of what is about to happen. Oftentimes, they're accompanied by parents who are pretty unhappy with the child's behavior. They might have taken a day off of work. They may not be focused on protecting the child's rights, but on making the child face the consequences of their actions. In addition, they're walking into a system that is a competitive adversary process, just like the adult criminal justice system. For better or worse, some people think for worse, but for better or worse, that's the system we have. And the people on the other side of the case are looking to prevail in the case. The consequences of these cases can be profound, even lifelong. And parents walk into these courthouses without lawyers for themselves or their children, oftentimes wanting to be cooperative, but really not understanding the consequences that may flow to their children. The process can be confusing. Prosecutors have an incentive to get the cases over with and not have to come back later and bring in witnesses. It may be difficult for families to understand what information is important to give to the judge, and significant decisions are made on that first day. The decision to either place the child outside the home or allow them to or continue living at home while the case is pending, what sorts of conditions of release. It's a quite significant, profound day in the case. So this proposal would immediately assign counsel when the petition is filed. This will make the system much more fair and protect the rights of children. Having a lawyer, though, at that first day in court can really make the system more fair and more efficient, because it can reduce the use of unnecessary restrictive placements when they're not appropriate, and that can save the state money. Related to this is what Representative Birch mentioned, is this issue of indigency. You'll see that in the provisions on that page, there's a limitation in the current law to basically only assigning counsel to indigent children, which basically means a child that can't hire counsel on their own. And the way that this is typically handled in the current system is that paperwork is filled out about the family's financial status, and the judge makes an assessment as to whether the family can afford to hire counsel. In juvenile cases, it's the child itself that is supposed to be able to hire counsel. So as you can imagine, very close to 100% of court-involved children are indigent. But the system works now that you don't really get your lawyer until you fill out the paperwork. So that's not a big deal now, but if we're going to assign counsel when the petition is filed, it's important that this paperwork not be an impediment to that. So I'd ask you that you consider modifying that language, and if the court is inclined, if the committee is inclined to do that, I have some proposed language to change those sections that I can provide to the chair. So I've just focused on a few parts of the bill. My colleague, Michelle Wangren of New Hampshire Legal Assistance, is also signed up to testify about a couple of other parts. I would urge you to pass this bill. It's a bill that will protect the rights of children, improve the outcomes for children, and along the way, I think it improves public safety and well-being, and I think it'll make the system work more efficiently and cost-effectively. I'd be happy to answer any questions.
Thank you, Mr. Skibby. Are there any questions for Mr. Skibby? Seeing none, thank you very much. So we have 5 more speakers on this bill, and we have until 10:45. I'd like to not run really late, so just please keep that in mind. Up next is Sarah Blodgett with the Judicial Council to speak in support of the bill.
Good morning, Madam Chair. This is Sarah Blodgett. Can you hear me?
Yes.
Yes, thank you.
Thank you. And thank you, Madam Chair and committee members, for taking my testimony today. I'm Sarah Blodgett. I'm the Executive Director of the Judicial Council. And the council is the state agency that is responsible for ensuring the quality and the cost effectiveness of indigent defense. The council members met on Tuesday to review this bill. Although we did not have a full quorum, the members, with the exception of the circuit court member who abstained, voted in favor of supporting this bill if it includes a fiscal note. Because we anticipate a significant increase in indigent defense expenditures if this bill is passed, and wanted to be very upfront about the costs that we see. But as you've heard from previous testimony, the Judicial Council has received this assessment from the National Juvenile Defender Center. It's very clear to our members that the representation of juveniles has evolved significantly over the past several years, and the national trend is to provide a more holistic model of representation. The assessment was very eye-opening for our members, and we've been working closely with the National Juvenile Defender Center and other stakeholders to address some of the issues that were raised. We were actually in the process of applying for a federal grant that will give us some financial assistance for training programs and to initiate a pilot program with a social worker who specializes in juvenile representation. And the National Juvenile Defender Center has been working with us on that application. This bill does an excellent job of addressing some of the most important findings of the assessment. And as you've heard and as you see, the sponsors were very thoughtful in their approach to these various issues. The Judicial Council feels very strongly that a fiscal note is needed because although the policy is supported, we want the legislature to be aware of the price tag for this. You've heard quite a bit of testimony about the concerns with the flat fee reimbursement model for our contract attorney program. And right now, a contract attorney is paid the same amount for a juvenile case, whether it's a simple misdemeanor criminal trespass or one of the most serious charges in our criminal code, an aggravated felonious sexual assault. The flat fee reimbursement model was actually implemented when the previous Governor Sununu was in office, and it was done as a way to contain costs for the layer of cases that cannot be handled by the public defender program. And in the last fiscal year, we paid approximately $45,000 for contract attorneys to represent juveniles. To switch to an hourly rate reimbursement based on those numbers would result in an increase of approximately $200,000 to $300,000 more dollars for that system. And I think everybody who's spoken before me has been very eloquent about the drawbacks of a flat fee system. We use that system in our adult criminal matters as well. Certainly it is now a disfavored reimbursement model. You've heard the issues with it. And although it does come with a significant cost, the council feels strongly that this bill with an appropriate appropriation would really go a long way to addressing one of the biggest concerns that the National Juvenile Defender Center raised. Costs for earlier appointment of counsel are not expected to be significant at all. As you've heard from Representative Birch, there would be costs associated with counsel representing juveniles who are being interrogated or questioned by the police. And there would also be a cost for representation in related matters. So although the policy is very important and very important to the Judicial Council, they did direct me to make it very clear that they believe this needs a fiscal note so that all of you can see what the costs would be. I want to thank the sponsors of the bill because this really, I know a lot of time and thought went into this. Their approach really was laser beam focused on the biggest issues that we are facing our juvenile justice system today. I won't take a lot more time. I know you have several other people to hear from, but the public policy piece of this thing is really crucial in terms of moving forward with our representation and enhancing it in the ways that we are being advised to do. And so the council is ready to make these changes, but want you to be aware of that fiscal impact. And I'm happy to take any questions that you may have.
Thank you, Ms. Blodgett. Are there any questions from committee members? Seeing none, thank you very much.
Thank you so much for your time.
Next up is Representative Mary Beth Walls to speak in favor of the bill.
I'm here. Can you hear me?
Yes, thank you.
Thank you. I too am cognizant of the time and I will try to be brief here. I just wanted to talk about some of the major points and highlight this. First of all, with respect to what Sarah Blodgett said, I now sit on finance. I happen to sit on Division 1, where I oversee the Judicial Council's budget. We would welcome a fiscal note that would help us determine what the appropriate amount is. So I think that would be terrific. More generally, I wanted to talk about the fact of where Representative Birch started with this. This has been a constitutional mandate since 1967. This is not something that is optional. And in fact, New Hampshire is probably facing the threat of yet more litigation because we are not appropriately providing counsel for juveniles. And litigation is just going to cost us money. Sometimes spending money saves us money. And this is one of those examples. We're spending a little bit more money here to provide appropriate counsel will actually save us money in the long run. We also know that early appointment is the best for the children, for the parents, and for the lawyers trying to represent them. It yields better and cheaper results. And it's very important that there be no reimbursement option or requirement, for the kids. What happens is when you have a reimbursement option for the juveniles, it means the parents are effectively paying it, and they often push a child to enter a plea or not to take other options available to them because they don't want to be stuck with the cost. And in fact, even the cost of a juvenile diversion program, which is only $100, sometimes that's too much for a family, and a parent will turn down that option because they're not interested in paying even a mere $100 for a diversion program. We also want to confirm that the right to counsel should not be controlled by a family's wealth or by geography. So parents with money can go out and get private counsel or pay these fees, where children from more impoverished families don't have that option and don't receive the same quality counsel. In fact, parents have a conflict of interest because it's the parent's interest to pay the least amount possible. It's the child's interest to get the best representation possible. And those often end up in conflict. We also know, I sat a year ago on a committee that looked at the recovery from the Office of Cost Containment and learned that the Office of Cost Containment just about breaks even. That with the amount of money that they seek from defendants, both juveniles and adults, to pay for lawyers, and the amount it costs to run that office is nearly identical. In all honesty, there is a slight net intake there, but it's so small as to really be meaningless. And in all honesty, the Finance Committee has looked at eliminating the Office of Cost Containment because the recovery is so low. There are costs that we often don't think of that come with this besides lawyers and a diversion program, the cost of investigations, the cost of having experts. There are a number of costs that come with really appropriate representation. Finally, I just want to talk about that these choices have lifelong consequences for these children. You heard testimony earlier that it affects employment, housing, and education. And what happens is that the choices made here really determine whether or not a child stays in the system. And a child who stays in the system is not contributing to society. And that in the end ends up costing us more money. So once again, not only is this more fair and more just and more constitutional, but it really is a cost saving for the state of New Hampshire. Thank you. And I'll take any questions if anybody has any.
Thank you, Representative Walls. Are there any questions for Representative Walls?
No hands.
Seeing none, thank you.
Thank you.
Up next is Catherine Cooper with the New Hampshire Association of Criminal Defense Lawyers to speak in support of the bill.
Thank you, Madam Chairman and members of the committee. My name is Catherine Cooper, and I appear here today virtually on behalf of the New Hampshire Association of Criminal Defense Lawyers. We don't testify too often in front of your committee, so I would just like to explain that we are a professional association of more than 250 Granite State lawyers who practice criminal defense and juvenile defense around the state. And our membership includes both private practitioners and state and federal public defenders. I'm going to be honest, I don't have a lot to add, and I'm going to make my time here very brief because we are really in agreement with the testimony of Mr. Skibby, Representative Wallner, and also the speaker from the National Juvenile Defender Center. I am going to submit some written testimony, however, and that testimony includes a couple of stories at the end that I hope that you can take a moment to review, because in preparing for this, I spoke with several attorneys, both public defenders and private lawyers who practice regularly in the juvenile courts. And I think that these stories really demonstrate the need for ongoing and early representation on the part of the children in the state. So I'm going to leave it at that unless anyone has any specific questions for me, and I will be submitting my testimony to you in writing.
Thank you very much. Are there any questions for Ms. Cooper?
I see no hands.
Seeing none, thank you very much.
Thank you.
Up next is Michelle Wangren with New Hampshire Legal Assistance to speak in support of the bill.
I have to find her.
First, we have to find her.
Oh. I don't know where she went.
Madam Chair, if she could spell her last name, please, when she arrives.
Pardon me?
If she could spell her last name. Oh, it's up.
Wangren. I see
She's on
her.
the screen for you folks.
See her hand? She has her hand raised.
Yep, she's under the attendees list.
Okay.
She's on the screen and ready to go.
Thank you.
Can you all hear me?
Yes, thank you.
Okay. Good morning, Madam Chair and members of the committee. My name is Michelle Wangren, and I'm the Youth Law Project Director at New Hampshire Legal Assistance. Through that role, I represent at-risk and system-involved youth to help ensure their educational and other needs are met and reduce the need for court involvement. Prior to my role at NHLA, I was an attorney at the New Hampshire Public Defender and frequently represented youth charged with delinquency offenses. I appear today on behalf of NHLA as well as the Juvenile Reform Project, which you heard about from Mike Skibby. While I support this bill in its entirety to prevent duplicating testimony this morning, I want to focus on two key pieces of legislation, Section 4, Paragraph 1A and Section 6. So Section 4, Paragraph 1A starts on page 2, line 24, and it really does two things. First, it allows defense attorneys to participate in ancillary proceedings when those proceedings are based on the same factual circumstances as the delinquency petition. And then second, it extends the appointment of counsel until the juvenile's case closes. Regarding the ancillary proceedings, simply put, this provision permits defense counsel to use their judgment to ensure they provide youth effective assistance of counsel without any arbitrary barriers. Rule 1.1 of the Attorney Rules of Professional Conduct requires lawyers to conduct proper case preparation. This includes inquiry into and analysis of the factual and legal elements of the case and use of methods and procedures meeting the standards of competent practitioners. The NJDC report found that New Hampshire attorneys underutilize investigators to adequately prepare cases. In juvenile practice, extremely valuable information is often learned and discussed at school or treatment team meetings, particularly when the delinquency charges stem from offenses committed at school or within a residential placement. Again, while it may not be necessary or appropriate for the attorney or investigator to attend all such meetings, it must be within the attorney's professional judgment to determine what competence requires in a given case, and without arbitrary constraint. This provision takes a critical step in allowing all juvenile defense attorneys to exercise that professional judgment. For instance, under current standards, it's a violation of conditional release for youth to be suspended or expelled from school. A youth may have any number of factual, legal, or disability-based reasons to overcome the underlying expulsion, but without legal assistance available to dispute or at least advise the youth through that process, any opportunity to dispute the violation of conditional release is dead in the water. Current practice discourages defense attorneys from even attending ancillary proceedings, such as school discipline proceedings or related meetings. While it's certainly not necessary to attend every such proceeding in every case, it's critically important that internal policies or procedures do not constrain the professional judgment of attorneys to decide what's required in an individual case. And second, Section 4, amended paragraph 1A, would require appointment of counsel to remain in effect until case closure. Historically, in New Hampshire, juvenile cases close within 30 days after the dispositional hearing and are only reopened immediately before any subsequent hearings. That could be 3 or 6 months down the road at best. In the wake of the COVID-19 pandemic, this practice was immediately recognized as unfathomable as it pertains to youth and out-of-home placements. Stakeholders agreed that with the added risks of congregate care placement during the pandemic are worthy to access to an attorney. But the need for a child's voice after disposition doesn't stop when the pandemic ends and was highlighted as a systemic failure in our state by the National Juvenile Defender Center. I'll start by saying that a child's removal from home is nothing short of traumatizing. Regardless of the circumstances leading to placement, it's often the first time they find themselves without a friend, without a trusted adult, and without the possibility of even an embrace by their family. How that child will respond is unpredictable. They could withdraw into themselves, they could begin quietly self-harming, or they could lash out at everyone around them. But once their attorney leaves them, there's nobody left to advocate for them. As an attorney frequently working with youth, I know that even when children are struggling, they forget to reach out to those they know will advocate for them. But if their attorney checks in with them, they will typically talk freely and gladly accept help to get out of often dire circumstances. When their behaviors are perceived as shortcomings of their character rather than reactions to their circumstances, they may be isolated, restrained, or transferred to more and more restrictive placements. Even when these children have involved parents, their parents are not always effective, nor do they have the ability or know how to access the court if warranted. The child is left with no advocate to proactively ensure their needs are met, their services are provided, or that they have case plans designed to help them return home. In my practice, I've worked with children who are struggling in their court-ordered residential placements, only to find out necessary special education services have been removed to meet the needs of the placement, without any prior discussion about whether it was an educationally appropriate placement to begin with. Even worse, some children's IEPs are summarily removed altogether shortly after they enter placement. Even if a residential school is able to meet the child's needs through its nature as a self-contained special education school, removing the IEP hinders this child's successful transition back into public school. Now, while these issues may not be the role of the attorney to fully resolve independently, discovering that a placement turns out to be wholly inappropriate for a child is certainly worthy of raising with the court immediately, rather than waiting for a hearing 6 months down the road, by which point the child could have disengaged altogether or worse, picked up new charges. Ensuring the child is in an appropriate placement is good for the child, good for the family, and prevents waste of state dollars on inappropriate and ineffective programming. The same holds true for children who have not yet been removed from their home. The very first stated purpose of RSA 169B is to facilitate the minor's development by providing the protection, care, treatment, counseling, supervision, and rehabilitative resources that a child needs. If a child doesn't have access to appropriate resources, research is clear that they will sink deeper and deeper into the system. A competent and involved attorney can help ensure they have access to appropriate services before the child reaches a breaking point and faces residential placement. Minimally, rather than closing the case until the worst happens, the attorney should remain apprised of the case status and any need for intervention or court-based advocacy. And then the last point that I want to make today, so the last point actually on section 4 is that it's not entirely clear to me what page 2, line 30 is designed to address. And Representative Birch had addressed this earlier, that taking on the added costs may be too big of a lift. But I do want to just point out that last year, the general court eliminated the parental reimbursement structure in juvenile delinquency proceedings, and this bill eliminates the reimbursement for juvenile counsel. So I'm not sure what costs are left that the juvenile may be responsible for, other than the possibility of a restitution payment. And if that's the issue that this language is designed to address, I would just recommend amending the line to take out costs and fees and to replace it with restitution. If there are some other costs that I'm not thinking of, then that should certainly be considered as well. And then finally, I just want to touch upon section 6, which starts at the top of page 3. This section prohibits the use of uncounseled statements at a juvenile trial. And one of the NJDC's greatest concerns about New Hampshire's system was our late appointment of counsel, with which Attorney Skibby spoke about earlier. And in his testimony, you heard about the need for timely appointment of counsel in an ordinary case. But this provision, section 6, provides an added layer of protection. Research is clear that kids are particularly vulnerable to the influence of adult authority and do not understand the implications of making a statement to the police. This is coupled by the fact that children in general, and children with disabilities in particular, are much more likely than adults to make false confessions. Children easily believe that if they are just cooperative, adults in authority will help them, but oftentimes that's simply not the case. Even when children receive leniency for cooperating, they typically still enter the system. And entering the system exponentially increases the odds of remaining in it indefinitely, dropping out of school, and entering the adult criminal justice system. This provision would provide the most basic protection that prior to making an admissible statement, the child would have the right to consult with counsel. Such a consultation would help them understand if the information they're providing would be helpful to the police or incriminating to the child. This is a good thing for the system. As you heard before, early appointment of counsel helps the system be more efficient. If it's information law enforcement is after, an attorney could help the child negotiate an agreement to provide that information in exchange for a developmentally appropriate program, for instance. Or the attorney could simply help the child understand the benefits and consequences of cooperating with an investigation to ensure the child's choice is informed. In the interest of time, I'm just going to limit my comments to that. But for all of these reasons and all the reasons you've heard from other advocates today, I urge this committee to vote ought to pass for on HB 188, and I'm happy to take any questions that you may have.
Thank you very much. Are there any questions for Ms. Rangren?
Pat Long.
Representative Long?
Thank you, Madam Chair. Thank you, Ms. Wangerin. So I was under the understanding also that last term, the costs are no longer in effect.
That's right.
So what you're saying here to change on line 30 cost and fees to restitution, if we change it to just restitution, is there any other fee or something else that may come up?
None that I can think of, but again, I'm not sure what the intent of that line was. And so I don't know if Representative Birch or other members of the Judicial Council had in mind what other costs that might entail, but I can't think of any costs that would remain other than restitution to a family.
Okay, very good. Thank you.
Thank you. Are there any further questions? Seeing none, thank you very much.
Thank you.
Next up is Moira O'Neill from the New Hampshire Office of the Child Advocate, but there are two on the screen. I need to know who is who.
Oh, sorry. I'm sorry. I'm Moira O'Neill. Can you hear me?
Yes, thank you very much.
we can't see the screen, so we can't adjust our names.
Okay, and we're on limited time. So.
Yes. Thank you, Madam Chair. It's good to see all the members of the committee again. For the record, I'm Moira O'Neill. I'm the State Child Advocate. And in the interest of time, I will provide a very abridged version of the testimony I have already submitted in writing. This bill has been well supported this morning and I just want to reiterate two areas. One is about understanding the development of children's brains and also the circumstances of children and their families. Regarding brain development, you heard Mr. Skibby describe the high incidence of disability amongst children involved in the juvenile justice system. Some would argue that a naturally undeveloped brain is a kind of disability in itself. And I know many of you know adolescent boys and girls, and you may agree with me on that. Absent counsel, the average child is at greater risk of waiving their rights, agreeing to conditions impinging upon their liberty, or making decisions that significantly impact their future. We know from very elegant imaging studies and other research that the frontal lobe of the brain, including the prefrontal cortex, is still developing well into the mid-20s. So that structure and function of that part of the brain is determining how a young person's ability to think critically and to reason is played out. So the lack of development in that area is often cited as to explain the antisocial behavior that children bring themselves into the juvenile justice system to begin with. And it's that same underdevelopment of the brain that places a child at risk of providing false statements or confessions without understanding the consequences of what they're saying, and often allowing themselves to be influenced to just agree to people so that they can get through an interview with law enforcement or prosecutors. So it's really important that representation is there to protect them. Regarding the circumstances of children and families, you heard a little bit about this today, but I want to reiterate the high incidence of behavioral disability among these children puts them at considerable risk for antagonistic relationships with their parents or their caregivers. There's also a large population of children in New Hampshire who are considered what we call crossover youth. They are actually abused and neglected children whose behavior is a response to their maltreatment. And we also know there's an overrepresentation of children from impoverished circumstances whose parents may encounter significant barriers to appearing at court and supporting them because of lack of transportation or work obligations. So all of those children are highly likely to be navigating legal systems without the support of engaged and protective parents or caregivers. And so the need for professional advocates and representation is really critical for them. The most common complaint that we hear from children when we visit at the Sununu Youth Services Center or other residential facilities where children are placed is that no one listens to them. We're often astounded when we say, where do you see yourself? What would you like to happen? And we just get blank stares, and the children invariably tell us, I don't know, no one has ever asked me that question. They really are left out of the process. And once their attorneys are gone from the initial delinquency proceedings, they don't, they may have a visit from a JPPO, a juvenile probation parole officer, once a month, but they don't have someone who's really engaged with them and making sure that their needs are met. Appointing legal counsel from the very beginning for the life of a case increases the chances that children are going to be heard. And we routinely find that children make very reasonable, often self-preserving suggestions for their care. So early and consistent legal counsel for the life of a case will ensure that they're listened to and that they receive any related necessary treatment and educational services for optimal rehabilitation. I'll stop there in the interest of time. If you have questions, I'm very welcome the opportunity to answer them.
Thank you very much. Are there any questions for Ms. O'Neill? Seeing none, thank you very much.
Thank you.
So I see Representative Ned Gordon has your hand up. Did you want to testify on this bill, Representative Gordon? Because I'm on very limited time.
He needs to unmute.
Representative Gordon? Representative Gordon, did you want to testify on this bill? Okay, hearing nothing, he can, I know it does, but he can submit written testimony if need be. So I am going to close the public hearing on HB 188. Thank you, everyone. And just so we know, there were approximately 80 people who signed in support of this bill. And there was no one that signed in opposition. So thank you. So up next, we have House Bill 427. I don't want to have to limit time, so please refrain from testifying for a half hour. Okay? And Representative Altschuler, I don't have you on my list as signed up to speak, but you're the prime sponsor. So are you speaking?
Good morning, Madam Chair. And yes, I filled out the online sign up yesterday to speak.
I don't know why you're not on it, but anyways, I'm gonna call on you first because it's your bill.
Thank you. And I will be very brief. And I have emailed my testimony to all members of the committee when you get a chance to look at that. Thank you, Madam Chair, and welcome everyone. I'm so thrilled to be on this committee. I will begin my testimony for House Bill 427 by saying children in New Hampshire deserve to grow and learn in an environment free from violence. Unfortunately, we cannot guarantee that for every child, and the place where they should be the most protected and safe, their home, can be a place of physical, sexual, and emotional abuse or tragic neglect. As a state, we've made a sincere effort in putting supports in place to help families create and sustain safe and nurturing homes, but not everyone is successful in that endeavor, and the state must step in to protect those children. When a child is taken into state custody, it is a serious decision that is not done in haste. A child removed from their home has experienced trauma from the events leading up to that removal, and then trauma of being taken from their home. The reasons for removing a child are encapsulated in the long studied body of work of adverse childhood experiences. And adverse childhood experiences are stressful and traumatic events that include physical abuse, sexual abuse, emotional abuse, physical neglect, emotional neglect, a mother treated violently, household mental illness, substance misuse in the home, the incarceration of a family member, or loss of a parent. An ACE score is subsequently calculated by adding up how many of those experiences apply to a child's life. And compared with a score of 0, people with ACE scores of 4 have a 400% increased risk of depression, are 25% more likely to experience teen pregnancy, and ACE scores of 4 or more are 700% more likely to be addicted to alcohol and are 1,000% more likely to inject street drugs. As documented in the evidence from Drs. Felitti and Anda, whose public health research developed the adverse childhood experiences body of work, an ACE score of 7 or more in children and adolescents increases the risk of suicide by 51 times. And further, 80% of suicide attempts during childhood and adolescence are attributed to ACEs. Children who experience chronic trauma suffer delayed brain development. The consequences of extended exposure to violence and abuse are found in underdevelopment of cognition, social emotional skills, and self-regulation due to that developmental trauma. Corporal punishment, as defined in this bill, Part 2, B, is quoted as means any punishment in which physical force is issued and intended to cause some degree of pain or discomfort. That is a description of trauma. Nothing in that description is an appropriate standard of care for children in state custody. It should be the goal of the state to put an end to the infliction of trauma on its children, not engage in violence or condone it in any form. Therefore, I submit House Bill 427 as a step towards ending violence against children in our custody. This bill was before this committee last February in the form of House Bill 1250. For those of you who are new to this committee or are new to the legislature, just a little history. This bill received a recommendation of ought to pass with a vote of 19-0 on February 19th, 2020. It subsequently passed the floor of the House on March 11th of 2020 on a voice vote. Unfortunately, after COVID-19 struck our state, this bill was not chosen to be absorbed in any of the Senate omnibus bills, which brings us here for another try. The first sponsor of this important child protection bill was our former colleague and esteemed member of this committee, the Honorable Dr. Skip Berrien. I will defer any questions to him and to the Office of the Child Advocate, Dr. Moira O'Neill, who is also with us today. I thank you for your time and attention and for your dedication to the protection of all children. And with that, Madam Chair, I will defer any questions to me to Dr. Berrien or Dr. Moira O'Neill. Thank you so much.
Okay, so up next is the Honorable Skip Berrien to speak in support of the bill. But he's speaking as a member of the public, so it takes a little to get used to not calling him representative.
Thank you very much, Madam Chair. It's really a pleasure to be back with you all. And in particular, I want to acknowledge my pleasure in seeing Representative Alicea and Representative Lewicki rejoining this committee. We had many good discussions over important issues in the past years, and it's nice to see you back on the bench, so to speak. So, as was said, I'm Skip Berrien. I live in Exeter, and I'm a retired pediatrician, former professor of clinical pediatrics at the University of Connecticut School of Medicine, and as you've heard, a 3-term member of this particular committee, this fine committee. My interest in the problems associated with corporal punishment of children extends back decades when I became aware of the groundbreaking research of Dr. Murray Strauss at UNH. The topic can raise strong feelings, both pro and con, based on personal experience and family history. But over the past 3.5 decades, research has demonstrated that corporal punishment as a method of controlling children's behavior is not only not effective in the long run, but is associated with long-term serious consequences, which have very significant social costs. There is strong evidence that corporal punishment places children at risk for physical injury, poor mental health, slower cognitive development, antisocial behavior, and tolerance of violence when in adulthood. You will hear more about this in the accompanying testimony from international expert Dr. David Finkelhor of UNH. He will bear these out in more detail. Significant studies show us that the use of corporal punishment is prevalent in our country. Again, Dr. Finkelhor's recent study shows that young children in particular are subjected to corporal punishment regularly, and it continues on into adolescence. As you heard last year, I introduced this particular piece of legislation. For several years, I sat on this legislation in an effort to find the most appropriate approach to ensure that the state of New Hampshire would clearly state that it does not condone the use of corporal punishment. Last year, the committee, as you heard, passed this legislation overwhelmingly in the committee and then passed it on to the House without any objection. Unfortunately, the pandemic prevented the Senate from taking up this bill. You may ask if this legislation prohibits corporal punishment in the home. No, it does not prohibit use of corporal punishment in the home. But with this legislation, all state agencies involved with children will discourage the use of corporal punishment in its programs, no matter if these programs are in the public sector, the private sector, or carried out in private homes. With all the accumulated scientific evidence, I ask this committee to again vote ought to pass and again affirm that corporal punishment is not an acceptable method to control children's behavior. Thank you, committee. Thank you, Chairwoman Rice. I will be glad to answer any questions that people have.
Thank you very much. Are there any questions for Mr. Varian?
Madam Chair?
Representative Lewicki.
Thank you, Madam Chair. Thank you, Dr. Varian. I have a question as to how prevalent is corporal punishment for children who are under state care? Is this truly a common issue, or is this unknown, or is it already prohibited? Thank you.
We certainly don't have any data in regard to that. And we have not perceived that it has been a specific problem, but we know that children who are in state care and are in foster homes are at times have been subjected to things that we wish would not happen to children. So I can't tell you that it is a prevalent problem in children in state care, but we want to just be absolutely certain that it doesn't happen to them.
Thank you, Dr. Varian.
Representative Belanger.
Thank you, Madam Chairwoman. Dr. Varian, are you aware of any policies that are in place in those state agencies that already have no corporal punishment in place?
To my knowledge, there's no specific policies. I will tell you that certainly in the Division of Children, Youth, and Families, there are practices that are encouraged, which to use alternative approaches to children's behavior problems. So I'm not aware of specific policies that spell out corporal punishment as being prohibited. Rather, I think the agencies have taken the approach of these are the ways that one should deal with children's behavior problems.
Okay, are there any further questions for Mr. Varian? Dr. Varian, the Honorable Varian, my friend, Mr. Varian. All right, thank you so much.
Thank you.
Have a great day. Up next is Moira O'Neill with the Office of the Child Advocate to speak in support of this bill.
She needs to unmute.
Ms. O'Neill, can you unmute?
I'm unmuted now. Can you hear me?
Oh, yes, thank you.
Very good. Thank you so much, Madam Chair, members of the committee, for having me back again to support House Bill 427, prohibiting corporal punishment of children in state agency programs. I will defer some of the scientific information that we provided in this testimony that you have in written form, given the expertise that you've heard and also coming. But also happy to take questions about that. But I will just, in the interest of time, shorten my testimony today a bit. It's the Office of the Child Advocate's mandate to promote the best interests of children. And by prohibiting corporal punishment, this bill protects children from the adverse childhood experiences of corporal punishment when cared for under a state contract. Currently, however, we just want to point out that the Department of Health and Human Services has very few contracts for services with providers, such as residential providers for children. They only have agreements or reimbursement arrangements. So we would suggest including within the definition of agency those entities that have an agreement with the Department of Health and Human Services and the Department of Education, just to be sure that it's covered. So I want to comment on what we know about adverse childhood experiences that you've heard from Representative Altshuler and Honorable Skibarian, largely because in these conversations, you typically will often hear a response where someone says, well, my parents used corporal punishment on me and I turned out okay. In the past 2 decades, we have learned so much about the relationship between these negative experiences and lifelong problems like heart disease, obesity, and depression, all outcomes that none of us would have anticipated or associated with corporal punishment. So there are things that happen to people in their lives because of these experiences as children that you might not associate as a bad outcome. But furthermore, as we all aim to invest in New Hampshire's future through its children, it's important to note that corporal punishment has been found to impact a child's cognitive function and learning. So the verbal methods of discipline in which caregivers seek to help children reason or explain the problem with their behavior can actually stimulate cognitive function. And that's what we want. We want children's brains to grow, not to recede in their growth. Healthy childhood development is reliant upon trusting, supportive relationships. So children involved in foster care or state-sponsored institutional care are already vulnerable because of the adverse experiences that brought them into the system, into state care. We can't expect them to build those trusting, healing relationships when the people whose job it is to protect them, in the child's view, actually harm them. So if we do promote alternative practices for discipline, we're investing in New Hampshire's future for optimal outcomes for these children. We don't believe that there's any caregiver who intends to harm a child when employing corporal punishment. In fact, we know that most believe, although erroneously, the use of corporal punishment will protect children from harm by teaching them to curtail dangerous behavior. The fact is, the average parent or caregiver doesn't have the access to empirical research or scientific journals to understand these outcomes. So prohibiting the use of corporal punishment in state-sponsored care positions the state to model best practice for parents. It also holds the state to a higher standard because the state has access to the latest science. And in any situation where the state replaces parents or caregivers, it's essential that the state provides care that's informed by empirical evidence and of the highest standards of care. Finally, while the Office of the Child Advocate appreciates the purpose behind the amendments proposed in the second section of HB 427, we note that there are some inconsistencies in RSA 627-6, that's the criminal code, that could be similarly amended to ensure positive child development. It may be something that the committee wants to consider going forward. But otherwise, we support House Bill 427 and urge your support for it as well, with the alteration of the definition of agency to include those entities that have agreements with the Department of Health and Human Services or the Department of Education. Thanks for taking my testimony. I welcome your questions if you have any.
Thank you very much. Are there any questions? I see you. Representative Altshuler.
I don't have a question. I'm going to try to lower my hand now too. Sorry. I don't have a question. I just want to let the committee know if you have not seen your email, there is an amendment in your email from OLS that addresses exactly what Dr. O'Neill was talking about, and it changes line 9 of the bill to say entity under contract or agreement. It adds in 2 words. So that's in your email right now. And I just, I figured it would come up at exec session, but it had just been referred to. So I want to let you know it's there.
Great, thank you. Are there any other questions for Moira O'Neill? Representative Belanger?
Thank you, Madam Chairman. Chairwoman, I apologize. Same question to you, Ms. Moira. Are you familiar with any agencies in the state that prohibit corporal punishment in their facility?
Thank you for the question. We have not seen that specific policy laid out, so I'm none that I'm aware of.
Thank you, Ms. O'Neill. Thank you, Madam Chairman.
Okay, thank you. Are there any other questions? Seeing none, thank you very much, Ms. O'Neill.
Thank you, Madam Chair.
And up next is Representative Amanda Toll to speak in support of the bill.
Thank you, Honorable Chairman Rice, Chairwoman Rice. Thank you so much. My name is Amanda Elizabeth Toll, and I'm co-sponsoring HB 427, a bill to prohibit corporal punishment against children in state care. I'm co-sponsoring this bill because I believe that New Hampshire's governing bodies have a moral imperative to act to keep our residents safe, especially our children in state care, who are our youngest and most vulnerable Granite Staters. Corporal punishment against children is a tragedy that severely damages both their physical and their emotional well-being. This is a fact supported by major children's rights advocates, including the American Academy of Pediatrics. The science is clear. Children who are taught that violence is a solution are overwhelmingly more likely to become aggressive adults and themselves violent perpetrators. Banning corporal punishment against children is not a new idea. Many countries across the world have banned this practice, including many democracies such as Sweden, France, Germany, Finland, Denmark, and Iceland and Norway, just to name a few. The idea of legally harming children in state care, children who are often poor and are disproportionately likely to have experienced previous trauma, is appalling. I think the vast majority of New Hampshire constituents, regardless of party affiliation, would support this bill. We share the fundamental belief that our children should be kept safe. I cannot emphasize this enough. Children who are under the care of the state have already experienced some form of trauma. It is the responsibility of the state of New Hampshire to protect our children from any more physical, emotional, or psychological harm. That is why I'm asking you to support HB 427. Thank you.
Thank you very much, Representative. Are there any questions for Representative Toll? Seeing none, thank you very much for your testimony.
Thank you.
Okay, up next, please forgive me for what I'm about to do to this first name. Resmi Oro.
Hello.
Dartmouth Hitchcock Medical Center Child Advocacy and Protection Program to speak in support of this bill.
Good morning, Madam Chair and committee chairs and representatives. I would like to speak in support of House Bill 427 as well as the director of the Child Advocacy and Protection Program at Children's Hospital at Dartmouth. I believe and literature supports that the more violence there is in any community, the more corporal punishment is also approved.
Are you there?
Indicate that 80 to 90% of families in the United States approve of corporal punishment in the family against children. However, again, research both in the United States and in many other countries show that corporal punishment, in fact, has only one positive impact on the outcome compared to 10 other impacts which end up with very negative outcomes. The only positive impact of corporal punishment is immediate compliance with what the caretaker is requesting. On the other hand, other things that we would like to come out of child discipline, positive child discipline, are impacted very negatively. The child morally internalizes that it is okay to hit other people when they don't comply with what you want. The quality of the relationship between the child and the caretakers is impacted very negatively. Child's mental health is affected negatively, which leads to poor adult mental health as a result of corporal punishment becoming one of the adverse childhood experiences, as multiple individuals mentioned this morning. Child becomes more aggressive because they role model after their caretaker, who is acting as an aggressor rather than an educator in their relationship with the child. Child internalizes antisocial behaviors as they grow up, and they become violent individuals who also approve of corporal punishment, which has a very fine line toward physical abuse. Obviously, corporal punishment almost overwhelmingly all the time occurs as a result of the caretaker being very angry with the child's behavior, and there is no guarantee that a child who is corporally punished will not be physically abused if the caretaker loses control. And as I mentioned, these children tend to grow up to become adult aggressors, adults with antisocial behaviors, and with tendencies to abuse their own child and even their spouse. When literature has supported all of these, as a child abuse prevention worker, I have always been against any kind of corporal punishment, but in the context of this House bill, the state starting taking the steps toward banning corporal punishment, at least in state agencies and in foster placement, is not only going to be a wonderful step toward educating our entire state population, but also will role model toward foster parents observing how things move more positively when they do not use corporal punishment with their foster children. I am hoping that they will also become individuals practicing positive parenting with their own children and will voluntarily choose not to use corporal punishment with their own children. Thank you very much, Madam Chairperson, and I'm open to any questions and comments.
Thank you very much for your testimony. Are there any questions? Okay, seeing none. Thank you very much.
Thank you.
Okay, that's it for my list. And I see, oh, wait a minute. Okay, so next up we have
Rebecca Ross.
Rebecca Ross.
Good morning, Madam Chair and members of the committee. For the record, I'm Rebecca Ross, General Counsel and Legislative Liaison for DCYF. I just wanted to provide a response to the question that was asked of whether or not we have any policies regarding this. And there is a prohibition of corporal punishment in both our foster care licensing rules and residential care licensing rules that we can provide to the committee as follow-up.
Thank you very much, Ms. Ross. Are there any questions, any further questions for Ms. Ross? Representative Long.
Thank you, Madam Chair. The foster care and residential care, are they consistent with House Bill 427?
Yes, it's a prohibition of anyone providing foster or residential care from using corporal punishment.
Okay, and the same has, with starting on line 19 of the bill, to prevent injury, other than to prevent injury yourself or others. That's all consistent?
I believe it's consistent. I will have to pull the actual rules and compare the language to say that it's identical.
Okay, and you'll be sending that to us, correct?
Yes,
Okay, thank you.
you're welcome.
Thank you. Representative Belanger.
Thank you, Madam Chairwoman. Ms. Ross, question to you. In order to obtain a license, these residential programs and foster care programs, are they required to adhere to the guidelines presented in HB 427?
Yes, so they're informed and trained on the rules and what the requirements are and need to agree to that to obtain a license. And then if they were to in fact violate those rules once they were licensed and a child was placed, then we would have the ability to investigate and take action on that license if they were inconsistent.
Follow up.
So just to be clear, if they did not adhere to those policies and guidelines set by the division, they would in fact lose their license after an investigation?
It would depend. Obviously, there's, a lot of facts that this would depend on, but certainly the most extreme result would be loss of that license or revocation. There could also be a corrective action plan if there was a misunderstanding or lack of clarity. So I wouldn't want to say that every time the issue raised, it would automatically result in a loss of a license. They would have due process. They would have a right to a hearing to determine whether or not they did in fact violate the rules. But essentially, if someone is not going to agree to not use corporal punishment, they would not be licensed. They would not be able to maintain a license. They would not be an appropriate provider.
Thank you, Ms. Ross. Thank you, Madam Chairwoman.
Representative Lewicki.
Thank you, Madam Chair. Thank you, Ms. Ross. Are there children in state custody who are not already covered by the policies just mentioned?
Not that are in one of the DCYF placements. There could be educational placements or mental health or behavioral health placements that I can't speak to, but certainly not in DCYF care and custody and in our placements.
Thank you.
Are there any further questions? Seeing none, thank you very much. Okay, so I don't see any other speakers and there's no one else on my list. So I'm going to close the public hearing on House Bill 427. And we will be in recess for lunch until 1 o'clock. Please come back a few minutes early so we can make sure. Oh, I'm sorry, Representative Long.
Thank you, Madam Chair. Is it the same link to get back in at 1 as we did at 9:30?
Yes. Yeah,
It is. Okay,
it is.
great.
You can,
Thank
you can stay on. I mean, you can just, put up your picture or whatever and just mute yourself. You don't have to sign out.
Okay, great.
Okay.
Thank you.
Representative Alicia?
Madam Chair, do you have the numbers for support and opposition possibly?
Oh, yes, I do. I'm sorry. So
Thank you.
there were 22 people signed in support of HB 427 and no one signed in opposition.
Thank you very much.
Thank you for the reminder.
No problem.
Okay, so everyone enjoy your lunch and we'll see you back at 1 o'clock. Thanks so much. I really think today's gone pretty smooth. So I appreciate it, everybody. Thank you. We'll see you in a little bit.
Representative Rice?
Yes?
I'm happy to mute the feed so that folks can talk during lunch. Could I just have a volunteer to unmute before you resume the meeting?
Sure, if I know how to do that.
Well, you have my number if anyone struggles with it.
How to unmute Representative DeSimone when we come back?
So
She believes so, but I'll text you if we have a problem.
Right.
Sounds good. Enjoy your lunch.
Thank you so much.
Okay, guys.
Hi, Scott. Here's my sound check. Just checking to see if you can hear me. Maybe all the way across the room.
Hi, Christina, can you hear me?
Yes, I can. Can you hear me okay? How we doing here?
Christina, can you hear me?
Yes, I can. Can you hear me?
Okay, I'm not hearing you.
Okay. You can't hear me?
Can you hear me?
I can hear you. Can you hear me?
I'm still not hearing you. Hold on.
Can you hear me now?
All associated cost is completely
Can you hear me now?
additional costs. In other words, it could give the impression that the cost of the contract is much higher than it truly is, or the new cost. Now, if the legislation is aimed at giving the public a chance to oppose a contract for whatever reason, then it's important to note that when
Can you hear me, Scott?
is finally ratified or approved by
Can you hear me at all?
law requires new financial obligations to the municipality.
Testing, testing. Can you hear me?
Yes. Can you hear me?
I can. I just gotta tweak it a little bit if you don't mind staying on.
Okay, not at all.
New costs crystal clear to the public and provide the public with an opportunity to weigh in with their elected leaders if they so choose. Look, we're proud of the contracts we secure for our members. We're certainly not looking to shield them from public view. In fact, we post them on our website too, and often post of them on social media because we are proud of them. We just want to be sure that what the public sees is what is actually approved by our members through a ratification vote, as opposed to something that.
Okay, Christina, can you try it again?
Yes. Can you hear me?
Yeah, are you talking right into your mic?
You're very faint.
Okay, are you talking right into your mic?
Yes. There we go. I can hear you now.
With the committee and the sponsor to refine the language of the bill, but until such time, we ask that you retain it. And I thank you for your time and consideration, and thank you all for your continued service during these very difficult times.
Seeing none, looking online for yellow hands up or anything. I don't see any.
We don't have any panelists. We do have one more speaker that has their hands up. Brian Hawkins.
Brian Hawkins, PA, New Hampshire. Hawkins.
Do you hear me better, Christina, now?
Thank you, Mr. Chairman. Can you hear me all right?
Yes, we can.
Okay, terrific. Again, thank you, Mr. Chairman. For the record, Brian Hawkins, representing PA, New Hampshire. We represent over 17,000 members across the state.
Christina, can you hear me better now?
I can hear you a little bit better.
You can continue, Mr. Hawkins.
Okay. Yeah, just trying to put my mic up. Is that a little bit better?
Yes, thank you.
Okay, terrific. So I think we also, have
Ooh, feedback.
here I signed up similar to Mr. Durkin, signed up because I think there's any issue with the intent, but that I think, as he said, it could be unintentionally misleading voters. So without going through my entire testimony, because I think both Mr. Graves and Mr. Durkin covered most of it, I would echo the points that Mr. Graves made about the tentative agreement not being signed. The points about item 273A3, Roman 2B states only cost items shall be submitted to the legislative body of the public employer for approval at the next annual meeting of the legislative body. And so the tentative agreement with non-cost items has been stated. I think that
Now, Christina.
Yeah, that sounds good. Can you hear me now?
Yeah, you sound great.
Perfect.
versus the governing body, as Mr. Graves said, one
How about right here?
Oh, that's phenomenal.
versus the taxpayer relationship, which is
And right here?
obviously responsible.
Can you talk again?
And I think that's why when this was
It's a little more muffled, but I can hear you.
keep those lanes distinct for that purpose. I also think that tentative agreements take all kinds of forms when they are when they finally are finished. I would echo some of the
And this should be a last one.
timeline of
That's pretty good. Yeah, I can hear you. Thank you.
Can anybody hear me?
Yes.
I know you guys can. I'm talking about people here. I don't think it's unmuted.
I have muted it. Is it?
Can you hear me?
It looks like it's popping up yellow as we speak.
Oh, no, you're not. You've got to unmute the system. I did. Can everyone hear me? Yes? Okay, they can hear me. Wait, no. That has to be turned off, whatever that is. I have to mute. Okay, wait a minute. Now let me try. Can you hear me now?
Yes.
Okay. All right, we're good.
Yes, we can hear you.
Okay, welcome back, everyone. Before we go on to House Bill 254, I would like to have us vote on sending HB 188 to LBA to get a fiscal note. We need a majority of the committee to send it there, and I think it's important that it go get the fiscal note. Otherwise, I'm concerned it's going to end up killed later down the road because we don't want to leave the judiciary in a bad position financially either. So does everybody understand what I'm saying? Yes or no? Yeah? Okay. So does anybody want to speak to that other than me or? Sorry, I've never done this before, so bear with me. Yes, Representative Belanger.
Representative Yokela he has not been bumped to.
Can you please move Representative Yokela to the panelist?
And if I may add, I think this is a very smart move and we should move to bring this to a fiscal vote.
Thank you. Does anybody else want to
Okay, he should be a
speak to
panelist
this?
now.
Okay, Representative Long.
Thank you, Madam Chair. I had to log back in because I had lost my audio for some reason. So what was the question?
So I would like to send HB 188 to LBA for a fiscal note. They never received it. And I just think it's the responsible thing to do.
Yeah, no, I agree. I mean, although we're just a policy, yeah, why not?
Right, but
Sure.
I don't want to send it on and have it get killed because it doesn't have it. Do you know what I mean?
Right. Sure.
And that way it can go to finance and they can put the money there for it. So I would.
Okay.
I would feel better. So, would anyone else like to speak to this? Representative Batchelor.
Yes, let me lower my hand. Thank you, Madam Chairwoman. I'm just curious, while it's at LBA, do we have to just put a pin in it, exec it later, or can we move forward and then whatever comes from LBA, send it along to finance? Just procedurally, how do we?
So, but I'm not going to exec it today anyways. But so I can get a more definite, I mean, it would have to go quickly because it would be then a second committee bill, which honestly is why I originally scheduled it first. Because I really thought it would go to finance. So, but I've already spoken to the speaker and said, I want this to go there. I just think it's the right thing to do. So, does anybody else have a comment or a question about it? Okay, so Representative Alicia, could you please call the roll on this? We have to have a majority to be able to send it, and then I'm just gonna take 2 minutes to call Pam back because she's only here till 2 o'clock.
Of course. Representative DeSimone,
Yes.
Representative Yokela,
He's there.
Yes.
Representative Lewicki, Representative Belanger,
Thank you, Representative Alicia. Yes.
Representative Cross, Representative Cross,
Not here.
no. Representative Litchfield,
Yes.
Representative Smith, no. Representative Long,
Yes.
Representative Ali Saya here. Representative Grossman,
Oh, not here. It's a yes or a no.
I'm sorry, I meant to say yes, excuse me. Representative Grossman,
Yes.
Representative LeVesque,
Yes.
Representative Wazir,
Present.
It's a yes or a no.
Yes.
Representative Patrigno,
Yes.
Representative Altschiller,
Alt Schiller, and yes.
okay, 1, 2, 3, 4, 5, 6, 7,
And the chair votes
4,
yes.
11, 12. And Madam Chair, Representative Rice,
Yes.
okay. So we're just missing 2,
Yeah. So, but that was unanimous for everyone here.
yes.
Okay, so we're going to recess just for 2 minutes. I'm just going to make this call and we'll be right back on. Thank you.
Okay, thank you.
So those that are in the room, except for the chairwoman, I'm having a hard time hearing them. I don't know if anybody else is experiencing that.
Representative Wong, can you hear me okay?
Yeah, very barely.
Hey, I can barely hear Representative Belanger. Representative Belanger, can you say something, please?
Sorry, the chairwoman had asked me to hang on. Can you hear me okay? Or is it better if I do this?
A tad, but you're much quieter. I mean, I turned my computer up loud, so now everybody's really loud, but you're still soft.
Can you hear
Are
us?
all microphones on in the room?
Just one more time. Can you hear me okay now?
I hear you better now. Thank you. But don't be offended if I ask you to repeat something, okay?
So just do me a favor, if either one of you wants to speak, just pull the microphone, the speaker closer to whoever's speaking, okay? Okay, was that 2 minutes? Because I'm done. So, all right, so I am now, oh, no, I'm not. You are. Representative DeSimone,
Yes.
you're opening this hearing, remember?
Yes. I am going to, at 109, open the hearing on House Bill 254, relative to the placement of minors in secure settings. And at this time, I will ask Representative Kim Rice to present her bill.
Thank you very much, Madam Chair. Madam Vice Chair. For the record, I'm Representative Kim Rice. I represent the District of Hudson and Pelham. And I bring for your consideration House Bill 254. In 2017, we had a very long and lengthy public hearing on a bill that would significantly reduce the size of the number of kids placed at the Sununu Center. And at that time, I was significantly opposed to the end result because I was deeply concerned that we would have a lot of youth running the streets without having the services they needed in their communities to help keep the public and the kids safe. Much to my joy, I was proven wrong. This has been tremendously successful for these kids. They, as of today, I believe the number of kids placed at the Sununu Youth Services Center is 8, as opposed to the over 100 kids that were there in 2017. What HB 254 does is adds more offenses to the list that kids can be placed out in their communities, getting services in the communities they know, rather than being committed to the Sununu Center. I'd also like to bring forth in your email is an amendment I also brought forward to what the amendment does is it's going to add 6. First of all, it's going to make it so that the kids that are detained at Sununu can also be cannot be detained for these same offenses, but it's going to put it out 6 months later than the effective date so that the courts have time to, get used to what's going on and make the changes that they need. And so that's really about it. I have more people that will have, more answers to your questions when they testify. So I'm going to defer to them. But when this was brought to my attention, I was very happy to sponsor it because I was so dead set against it before. But I'm very happy that I was wrong. And I say that it's really important that we have these kids in their communities, and now that the services are there more, I think it's important for the kids going forward. So on that note, if you don't mind, I would like to defer the questions to the person that's going to come on after me. Okay, thanks for your time.
Thank you, Representative Rice. The next person to testify will be John DeJoy. John, are you there?
Yes, Madam Chair.
From Waypoint, can you introduce yourself and tell us what you need us to know?
Thank you, Madam Chair. Good afternoon, Madam Chair and members of the committee. It's a pleasure to be before the Child and Family Law Committee, albeit virtually. I rise today in support of House Bill 254, as Representative Rice just stated, as relative to the placement of minors in secure facilities. My testimony today will refer to the amendment that Representative Rice just spoke to. The amendment replaces the entire bill, and I will explain the differences between the two and the reasoning behind it. I come today representing Waypoint and the Juvenile Reform Project. Waypoint, which was formerly known as Child and Family Services, has been in operation since 1850, and you heard mentioned this morning by Mr. Skibby of the Juvenile Reform Project. I have forwarded testimony to all of you, and I'm going to do my best to excerpt the testimony and not read it. So to speak to the actual amendment, to get into what this does and what this doesn't do, there are three key sections in the amendment, sections 2, 3, and 4. And I'm going to speak to them. I'll speak to section 4 first, because that's perhaps the most impactful. As Representative Rice stated back in 2017, this committee made changes to offenses whereby a child could be incarcerated at the Sununu Youth Services Center. This makes further changes to offenses that a child can be incarcerated for at the Sununu Youth Services Center. And what this does is it limits incarceration to serious violent offenses. As outlined, I won't go through the specific offenses unless people have questions, but they're outlined here. I will point out to you that in the amendment, the bulk of section 4 is existing language. The changes to the language begin down where it gets into the specific offenses, but everything else in there should be existing language. So as of January 1st of 2022, this would go into effect if you ordain to pass it, and children who are committed would have committed a higher level of offense. Going to section 2, section 2 is in regards to the detention of children. I'm sure you all know this, given being on this committee, but I'll point it out that commitment is when the child is effectively convicted and incarcerated. Detention is when a child is held by court order while awaiting trial. So in section 2, what that does is maintains the current detention standards. So today, a child can be detained only for reasons that they can be committed, is what the current language says. We want to maintain the children who can be detained to be the same as it is today for the first 6 months that this is in effect. The reason for that, and I'll get into some of the specific programs, but the reason for that, as Representative Rice stated, is we would like to give the court and the department more time to roll out their system of care that they're working on now, and more time to acclimate to these changes. So between January of 22 and July 1st of 2022, any child who is detained today can be detained then. Section 3, which doesn't go into effect until July 1st of 2022, says a child can only be detained if they can be committed, meaning it raises the level for detention to the higher level offense as in commitment. The other pieces are the statement of findings and then the effective date. So that's what the bill does. Why is this bill important? Well, the bill is important for a number of reasons. First, as you heard the OCA testify this morning, you also heard a number of other witnesses testify that kids don't do well when they're incarcerated. It is not an effective intervention generally for children, and there are significant adverse effects when children are incarcerated. Dropout rates increase. We see increased trauma. We see kids often become more engaged with the adult correction system. And keep in mind that as the OCA also testified this morning, a number of these children at Sununu are what she referred to as crossover kids. I've never heard that, but they're kids that grow out of the abuse and neglect system and into the juvenile justice system. It's important to keep in mind that, as Representative Rice indicated, in 2017, there were significant questions about whether there were services to treat the kids that we were keeping out of Sununu. That was a major topic of discussion. What I would point out to you today is we're in a very different place. The federal Families First legislation went into effect a couple of years ago. It's required to be fully implemented by October of this year. What that requires is to treat children in the community unless congregate care is the only solution. It will emphasize community-based care, which is why you all 2 years ago enacted SB 14, the State System of Care Bill, and funded it with $20 million, because that bill permits the department to build out its system of care in order to comply with the Families First legislation. I'll also say that the broad system of care, which focuses again on community-based care, is good for our kids. And it will have a long-lasting impact. And that's why this time is right to bring this bill forward. All of these things are coming online currently. This legislation before you, in fact, doesn't become effective for several months after the system of care is built out. So the system will be in a very different place than it was in 2017. Today, we run between, you heard Representative Rice say the census is 8. I've seen the census as high as 15 or 16 in the last 6 to 8 months. That's the range it's been in. It's been about half committed kids and half detained kids, typically. What this legislation will likely do is at least have that number, if not more. We believe that this legislation creates an opportunity to continue to move away from the use of institutional and congregate care in the state and emphasize on treating kids in their community. Because what we know is that any child committed to Sununu will be returning to their community at some point. They don't learn to be effective community members when they're in jail. They learn to be effective community members by having supported treatment in the community where they can actually try out what they're learning. So with that, I'm happy to answer any questions the committee might have. And I would ask the committee to please pass the legislation as amended before you. Thank you very much.
Okay, are there any questions for John Joy?
Okay, so we have Representative Long.
Representative Long.
Thank you, Madam Chair. Mr. Joy, this has no effect on contracts with out of states, correct? With respect to the Sununu Center?
I'm not sure I understand the question, Representative. Could you rephrase that?
Well, if we contract with children being placed from out of state, would this have an effect on them? Would we have to, so let's say there's a child in incarceration in Vermont that doesn't fall under any of these. Would we be able to contract with them being at the Sununu Center?
So you're talking about placing incarcerated kids from other states in the Sununu Center?
Correct.
Okay. So my understanding, I am not a lawyer, but my understanding is that this applies to children arrested and convicted in the state of New Hampshire. I do not believe it applies to other contracts, although I would defer to Mr. Ribson or someone else who might have a better handle on that. I'm getting a text, sorry. Getting a text that I'm trying to interpret. So I don't believe it stops kids from Vermont, but Representative Long, I may be incorrect on that.
Okay, thank you.
Okay, I'm being told by an attorney I work with that my statement is correct. That this does not impact kids from the contract bringing kids in from Vermont. I would say for the committee's benefit, it's my understanding that contract only extends till October of 2021, when Vermont expects to have their own program, and this does not go into effect until January.
Thank you, Mr. Joy. appreciate your testimony.
I have more questions. People have questions.
And
Representative Lewicki?
Madam Chair, would it be appropriate for us now to vote to replace the bill as passing to the members?
No, we
Not at
handle
this
that in, during our work session, exec session.
Yep.
Are there any further questions for Mr. DeJoy? All right, seeing none.
Okay.
Thank you very much.
Thank you.
Our next person to speak will be Mr. Michael Skibby. Can you please introduce yourself? Whoop, let me put you on. Come on. Can you please introduce yourself, Mr. Skibby, and let us know where you're from?
Yes, thank you, Madam Chair and members of the committee. My name is Michael Skibby. I'm the Policy Director at the Disability Rights Center and also part of the Juvenile Reform Project. I want to thank Representative Rice for her sponsorship of this bill. You've been a longtime supporter.
Mr.
Excuse me?
Skibby, we're having a hard
Yes.
time hearing you. Can you speak up a little, please?
Yes, how about that?
Thank you.
I want to thank Representative Rice for her sponsorship of this bill. She's been a longtime supporter of reform of the juvenile justice system, and we very much appreciate that. The Disability Rights Center supports the bill as it is being proposed to be modified by the chair's amendment because it will reduce the use of the Sununu Center, particularly for minor offenders, which research shows is associated with lower recidivism and better outcomes for children, families, and public safety. I'm not going to say very much because it's been said already, and I don't want to repeat that testimony, but I do want to emphasize a couple of things. There's been some mention about how the effects of corrections placement for children can be quite negative. It is especially negative for children who are minor offenders. The relationship between how we respond to minor offenses and how the kids who commit those offenses in the future is very striking when you're talking about minor offenders as compared to more serious offenders. A child who's just starting to get into minor trouble is often someone who, with the right intervention, can do very well in the future. And there's lots of stories of people who've had just minor contact with the justice system who went on to live successful lives without further court involvement. Those interventions are often most successful when they do not remove a child from their home and school, because those removals can weaken and sever the connections that are protective against antisocial behavior. Now, those are connections with peers who are pro-social, with your own family, with teachers and coaches at school who are providing helpful guidance to a child, particularly a child with a disability who may be at risk of delinquency. These effects are less striking, however, with more serious offenders who may need more intense intervention. So it is definitely true that corrections placement should be avoided whenever possible, when it's not necessary to protect the child or to protect the community. But the difference is most striking when you're talking about the kinds of offenders that this bill would remove from eligibility for placement at the Sununu Center. And that's one of the reasons that we strongly support this bill. I think that everything else has been said. I just comment that New Hampshire's reduced use of interventions like the Sununu Center runs in parallel with what has been happening nationally. From 2003 to 2015, the rate of use of corrections placements for children went down by 53%. Now, part of that was a deliberate change in policy in many states, just like New Hampshire has decided that it's better and more cost-effective to reduce the use of facilities like the Sununu Center. But it is also because there's been a significant reduction in demand on the juvenile justice system as a whole, because the juvenile crime rate, just like the adult crime rate, has been in decline since the 1990s. The arrests nationally of children went down by 50% from 2006 to 2019. I don't have an exact statistic for New Hampshire, but I've certainly seen statistics in New Hampshire that show we've had a significant decline in the number of delinquency petitions that are brought and the number of cases that have been brought into court over that same period of time. So I'd ask you for your support of the bill as amended. I think the amendment is very key to making this bill work successfully. It will be better for kids and a more effective use of scarce public resources. I'd be happy to answer any of your questions.
Thank you, Mr. Skibby. Do we have any questions for Mr. Skibby? Seeing none, I thank you very much for your time and information. And the next person we'll speak with will be Rebecca Ross. If you, Rebecca, can unmute.
Good afternoon. Yes, thank you, Madam Chair, members of the committee. Can you hear me all right?
Yes.
Great, thank you. For the record, my name is Rebecca Ross. I'm General Counsel and Legislative Liaison for DCYF. We are not taking a position on this bill, but we did want to provide some background information. In advance of the hearing, I provided a number of documents via email to the committee's researcher. I hope you have those or will have them shortly. We also have Erica Ungarelli from Children's Behavioral Health on the hearing today, who can answer questions related to behavioral health to the extent those arise as well. To start with, we just wanted to provide some background. And two of the documents I provided were from DCYF's data book, both page 8 and page 20. Page 20 looks at the use of Sununu Center. And as you look at that, it will reflect exactly what you heard the other folks testify today, that the use of SYSC has decreased dramatically since 2016 through fiscal year 2020, which is reflected in there. Last year, the average daily census was 16.9. And in the last few months, we've seen slightly lower numbers as well. So we want to make sure that as we're making further changes to who can be committed, that we avoid any unintended consequences and understand where we're starting from if we're going to continue to make shifts. A couple additional facts from the data book that I think are relevant are that last year there were about 1,700 delinquency cases. Of those delinquency cases, less than 400 were in placement. Of that number in placement, a much smaller portion were committed to SYSC. So that's what we're talking about, a very, very small number of cases and folks. And the question is, where should that line be drawn on who can get in? I think that the offenses that are listed are absolutely appropriate. Murder, attempted murder, aggravated felonious sexual assault. No question, those have already been identified as the serious violent offenses. And we heard testimony about minor offenses. But the question for you really is, what's in between and how should those be treated? Because the most serious offenses are identified. The minor offenses already are not coming in the door to SYSC. But have we drawn that line in this bill so narrowly that we are going to be removing the safety net in cases that we need it? So an additional document that I provided you with, and I don't know if all of the members of the committee are familiar with this or not, but it's the court's detention screening instrument that is used every time the court is asked to issue a detention order. And attached to the instructions, which are also provided, is a list of all of the offenses and how they rank and how they are considered. And a thoughtful group of folks, including defense attorneys, went through and amended that effective July 2019 to really rank the risk level associated with different offenses. And you'll see on that list that there are a number of tier 2 offenses that are certainly very intimate offenses, personal offenses against other individuals that are not included on the list for which commitment is contemplated in this bill. Now, this bill, as Representative Rice said, it's to encourage treatment in the community, and all youth who are within the delinquency system are absolutely have the ability to avail themselves of treatment in the community. What this is really looking at is who can we treat in a secured facility when that's absolutely necessary. And so another document that I provided is a list of the statutory provisions related to some of those tier 2 felony offenses and the description of what they are. For example, we have a number of youth at SYSC that are there for simple assault. And if you look at our definition of simple assault, it does include bodily injury. And there are kids who are not eligible to be in any other residential program because they will not accept them because of their aggressive behavior. Now, whether or not simple assault fits into the list of minor offenders, I think you have to look at the facts and circumstances of that, and to remove that ability from the judge for that small number of youth that we're talking about should be carefully considered. So I'd ask you to consider that list, looking specifically at things like human trafficking, offenses against minors under 13, domestic violence is not included in that list, resisting arrest and causing bodily injury to an officer is not included in that list. There are a number of things that if we're removing from that list, we need to consider what the outcome of that would be. Looking at the purpose of 169C, the delinquency statute, it includes providing protection, care, treatment, counseling, supervision, and rehabilitative resources. The department is absolutely committed to providing those in the least restrictive, most appropriate environment. We just want to make sure that we are not narrowing the system too much that we don't avail ourselves to the most appropriate setting for some of these youth. So in considering the unintended consequences of this bill, if we are looking at not allowing commitment for some of these offenses that are not included, we risk having youth that cannot be placed anywhere because their aggressive behaviors prevent them from being placed in other residential facilities. Again, we're talking about a very small number of people, but we do think those folks exist. As well as how will the rest of the system respond? And we would be concerned that if prosecutors in the criminal justice system believe that the delinquency system is not responding, we will actually see an increase in the number of petitions to certify 16 and 17-year-olds as adults and move them prematurely into the adult system because the juvenile system is not responsive enough. And we would have concerns about not being able to provide a rehabilitative system through delinquency and forcing kids at an earlier age into a more punitive adult system where they would actually be detained at SYSC for a longer period of time pending certification and potentially face transitioning to the adult corrections system when they age out. And if we narrow the system too much, we risk seeing that. We also are concerned that we decrease the ability to reach settlements in some of these cases where we see second-degree assaults or aggravated felonious sexual assault pled down to simple assault, knowing that the individual will be able to get the treatment they need in a secured facility. And considering victims in the community, if that is no longer an option, are we going to see a reluctance to enter into agreements and actually be pushing toward a more punitive or higher level offense, which I think would be an unintended consequence of this bill. So in addition to those concerns about what will happen to that small number of kids in between that may not be minor offenders, but aren't on the list contemplated in the bill as proposed, as well as the timing, we just ask for you to thoughtfully consider if this is where the line needs to be drawn at this time. I'm happy to take any questions.
Okay, thank you, Ms. Ross. Any questions for Ms. Ross? Representative Belanger.
Thank you, Madam Vice Chair. To Ms. Ross, this is Representative Belanger. How often is the detention tool overridden?
I don't have that in front of me. We could reach out to the courts to ask for that information. They track all of the screening instruments.
Okay, thank you.
Representative Luigi?
Thank you, Madam Chair. My question is, if we are going to take people out of Sununu, I've been hearing a lot about the use of restraints in other facilities, and might we be putting kids into a situation where another facility, a lesser facility, would have no choice but restrain them?
I think that's one of the concerns, that facilities have to assess their risk and the ability to keep kids safe. And one of the reasons why they may not accept a youth is because they don't feel like they have the tools to keep them safe, and don't want to be in violation of the restraint and seclusion laws, and don't have the ability to have a architecturally secure facility for them.
Thank you, Ms. Ross. We appreciate your time. Next, we will go to Michelle Merritt. Thank you, Michelle. If you could unmute yourself, please. And welcome. Can you introduce yourself, please?
Sure. Thank you very much. Hopefully everyone can hear me. Madam Chair and honorable members of the committee. For the record, my name is Michelle Merritt. I'm the president and CEO of New Futures. Can you hear me?
Can you speak a little louder, please?
I will try. Is this any better?
Yes, thank you.
Sure. I'm the president and CEO of New Futures. We're a nonprofit, nonpartisan health policy and advocacy organization located in Concord, but doing work statewide. Our mission is to improve the health and wellness of all Granite Staters. And for the past several years, we've managed a policy agenda with a very specific focus on children's behavioral health. In this role, we have also participated as a member of the Juvenile Reform Project, which has been mentioned by some of the previous speakers. And we too support the bill with the amendment previously described. The previous speakers did a great job of outlining exactly why this is important. The only thing that I will add is that as the department works towards full implementation of the reforms in Senate Bill 14, which are the reforms around the children's system of care, we believe that the array of community-based services available to support these children who are multi-system involved and require significant mental health supports will be available. And again, as the other speakers have said, we strongly believe that connecting these children to clinically appropriate community-based services is a more humane and a better alternative to incarceration for many of them. And we know the outcomes are better when children can remain in their communities, and it's better for their long-term health as well. So I'll yield the rest of my time. I think the other speakers have covered it well, but I'm happy to answer any questions that committee members may have. Thank you very much.
Thank you, Ms. Merritt. Does anybody have any questions for Ms. Merritt? Seeing none, I want to thank everybody, and I will turn it over to Representative Madam Chair Rice.
Okay, so so now I've had everyone who has signed up to speak. If there is anyone on the attendees list who wants to speak, if you raise your hand, we will be sure to get your testimony. But the people I've called on are the people who I had on my list. So if there's any additional testimony, please raise your hand and we will call on you to testify. I'll give you a, there we go. So Erica Ungarelli.
Can you unmute, please, Erica, and introduce yourself?
Good morning, everybody, or good afternoon, everybody. It's not morning. Erica Ungarelli. I am the director for the Bureau for Children's Behavioral Health at the Department of Health and Human Services. I just wanted to add a little additional information from what Rebecca Ross had said. I've reviewed the bill. I have not yet seen the amendment. From the description of the amendment, it sounds as though one of the requirements around the care management entity has been taken out. And if that's the case, that's fine. We do, through the care management entity, accept any children referrals for children who require that intensive level community-based support. That does include any child involved in the juvenile justice system already. So we don't necessarily need a requirement around that. And I just wanted to reiterate some of the concerns that Rebecca Ross had stated around the one or two instances where we've had children with very intensive needs and have had some real aggression issues become sort of either stuck at an emergency department or at a psychiatric hospital for longer periods of time than anybody would want them to be there. Trying to find the next best treatment option for them. So that's just a little information that we have seen happen in the system today. We are working really hard on all of those requirements within SB 14 and to broaden the bench of behavioral health supports for all children who require them in New Hampshire. A lot of those areas will be implemented very soon, and that will help for sure. But again, as Rebecca Ross had stated, there are going to be those one or two couple of children that we've seen come through that really requires something more intense, a little more secure than what we have today and what we still may not have in the future once we've implemented all of our requirements. And so that's just an example we have seen to date and will likely see again in the future at any given time. So I'm available for any questions.
Thank you. I do see one question. Gabby Grossman, can you unmute and ask your question?
Hi, thank you for taking my question, Madam Vice Chair. Related to those situations where people are left in the emergency rooms for long periods of time, are there any solutions for that population right now in the works? And
yes. Mm-hmm. Absolutely. We have a number of different interventions that we are currently working on implementing. And I'm happy to go through the list. I'm happy to report that under usual circumstances, this does not happen a lot for children in New Hampshire. We're seeing the rise of numbers of kids at emergency departments, I think because of COVID. So the numbers are higher now than what we're used to. So under normal circumstances, we don't run into these situations where children are at emergency departments for long periods of time. That's the good news. What we are doing to address those issues are, the first thing is we are working to implement and very close to implementing stage 1 of statewide mobile crisis for children. So that with the hopes that children and adults alike will not have to go to the emergency departments in the first place to address their behavioral health crisis. Secondly, we have expanded greatly our intensive community-based programming that is implemented by our care management entities, of which we have 2 in the state. So our numbers in that intensive community-based programming has risen from 100 well up over 200 children being served in that program right now. And that's the program that we refer to as Fast Forward. We also are including another program in the book of business of the care management entities to follow children in residential treatment to be able to help them transition appropriately back to their home community. We are also going through a complete residential treatment transformation work. This is spurred on by a number of different things, one being the federal Families First legislation that you heard a little bit about today, the 10-year mental health plan, and the child welfare transformation recommendations, all align to give us the impetus to redo the entire residential treatment system in New Hampshire, where we will have 5 different levels of care that will hopefully meet most, if not all, of the needs of the children in New Hampshire. So we don't have children going out of state. We don't have children lingering in psychiatric hospitals. I think that's the list.
Thank you, Ms. Ungarelli. Do I see any more questions? Representative Belanger.
Thank you, Madam Vice Chair. Question to Erica. I apologize. I can't read your last name and I don't want to butcher it. I apologize.
Ungarelli.
Sorry?
Ungarelli.
Ungarelli?
Yes.
Okay. In regards to you referenced the number of kids in emergency rooms. Do you know off the top of your head the data that you have regarding how many kids entering the ER are juvenile justice kids, or just children entering the ERs with private insurance for mental health reasons?
Certainly. I don't have the breakdown of children who may be juvenile justice involved. We do have the breakdown of children who are enrolled in Medicaid versus commercial insurance, and we'd be happy to send that breakdown to you.
Thank you.
You're welcome.
Any further questions? I see no hands and nobody's trying to get my attention. So we thank you very much for your testimony and information.
Thank you.
Thank you very much. I don't see anyone else, Madam Chair, who wishes to testify. I don't see anyone else who has any questions, Madam Chair. So I will entertain a motion to close. All right, I'm just going to close the hearing on House Bill 2.
Rep. DeSimone?
Yes.
Do you have the list of people that signed up to support and oppose without testifying?
Yes.
Could you read that before we close this?
We will.
So we had 20 people that signed in support, and nobody signed in opposition.
Yep. Does that
All
answer
right.
your question, Representative Yurkela?
Yes, thank you very much.
Very welcome.
Okay, all right, everybody. Thank you so much. We appreciate your time, your patience. I think it went pretty good. So I hope you all have a great day, and we'll see you back here next week, and we'll do it again.
Yay.
Okay? So have a great night. Drive safe. Bye-bye.
I wanted to,
Yeah.
I wanted to ask on, so I see we have a Wednesday on the 2nd, I believe.
Yes.
So do we know if there's going to be a day or 2 days that we could block out?
Well, we're working on that right now. The problem we're running into is there are some committees that need 2 or 3 days because they have so many early bills. So for the next few weeks, we're not going to really have a blocked day. I am trying for Thursdays. It just turned out that originally we weren't going to meet next week because they needed all the days for the committees that have early bills. But because they ended up having that one day, they offered it, I took it because I don't want us to get, really far behind and feel rushed in our work. So I did that, but I am going to try for Thursdays, but right now everything is just such a work in progress that, we're trying.
So and another question, are we still sticking to if you're a co-sponsor, you can't ask questions? Because I asked a question and I'm a co-sponsor, so I should have done.
No,
So we're gonna stick with that.
We are, but listen, it was our first day And I think we all did pretty good.
Yeah, it was done well. Thank you.
You know, I think that, you know, things are going to happen, but we'll do our best to, you know, stay on top of it all. It's so hard with us in separate places and over the computer and everything, but hopefully we're on the other side of this pandemic, and you know, now that we have the vaccine and everything will start getting better for us, and we'll be able to breathe again with no masks. It'll be nice. But yeah, so does anybody else have any other questions?
So can I leave Representative Long's question on? Because I put it in the notes.
Oh, sure. Go ahead.
Okay.
Yeah, I'll make a motion to censor him.
That darn Representative Long. All right.
you.
Well, have a great night, everybody. Thanks so much.
Thank you. Thank you.